Good evening, everybody. I hope you are all doing well. Jonathan Ginsberg here on a very nice Wednesday evening. I hope you are having a nice evening as well. Hope you had a nice Memorial Day. It's obviously a day of reflection and it's a day off. So hopefully everybody had a meaningful one, and hope you again are all doing very, very well. All right, let's kind of jump into the questions. No guests tonight. It's just going to be me answering questions. Christina, one of our usuals, says hello from California, and she reminds everybody to like, share, comment, and subscribe. I would agree with that. If you can leave me a comment or subscribe, that would be great. She also says, please leave me a 5-star review. I'm not going to argue with that. I appreciate that very much if you will do that. So thank you, Christina, and welcome. Good to see you here again. Okay, Wayne Quarter says, I'm 6 months into the SSDI process with 35-year work history, 53 in upcoming fusion surgery and charial fusion surgery. I have a CE before the surgery. What would happen to my claim at this point? And let's see, continues along with the surgery. I have 5 surgeon visits with notes restrictions. Also failed epidural cervical injections, 1 MRI and 3 X-rays. My last job was National Park Service. What would your advice be at this point? Well, I mean, I think obviously you need to go to the, you don't say you're 6 months in, so I'm guessing you're still at the initial application process stage. I would say, you've obviously gone through some conservative treatment. The epidurals have not worked. You are now a surgical candidate. The CE, the consultative evaluation, should reflect that you are a surgical candidate. It may be enough to put you over the top, as would be the notes from your doctor. At 53, and again, whenever somebody's over 50, I look at the grid rules as a possible argument. You would need to look at the sedentary grid rules, which means that you would have to show that you're limited to sedentary work. Sedentary work is defined as standing and walking 6 hours. Standing and walking 2 hours in a day, sitting for up to 6 hours, lifting 5 pounds frequently, 10 pounds on occasion. So again, it doesn't take a lot to get there, but obviously you need a surgery. So sometimes you can win on the grid rule. I had one this morning where we won on the sedentary grid rules. It was a diabetes case. I think the young lady I represented is here tonight, but it can happen. But, the CE consultative evaluations are not always particularly helpful. What I would do is I would argue that you meet the grid rule at sedentary, that, that given that you're a surgical candidate, that you would argue that you're limited to less than sedentary, or in the alternative, no more than sedentary, and that, you should be found disabled on that basis. No guarantees that's going to happen. The consultative evaluation, if it's in your favor, might persuade Social Security to or issue an approval. My experience has been when somebody is scheduled for surgery, the default that Social Security will do is they want to wait and see what happens at the surgery. In other words, instead of saying, yes, you are disabled now, and, going ahead and approving you, and then dealing with what happened for the surgery about a possible review, more likely they're going to go ahead and turn you down, see what happens with the surgery, and then at a later stage, whether at recon or at a hearing, we'll see how the surgery went. Now, obviously, as you know, there is a duration requirement in disability cases, meaning you have to show that you have been out or will be out for 12 consecutive months. So if you have not been out for 12 months, that would be another reason why they might not approve you. They would say, well, we don't know if you're going to be back to work after the surgery. You haven't been out for 12 months. The surgery is within that 12-month duration. Therefore, we don't know what's going to be. So my point here is I wouldn't get overly optimistic about it. I think that, this is a case that my guess would be they'll turn you down at initial, they'll turn you down at recon. By the time you get to a hearing, you will know whether the surgery was effective, whether you can go for ongoing disability or a closed period. You have a stronger argument as you get, at a hearing. So in a year from now, there'll be a lot more known about it. That's frustrating as can be, I know, because you're probably looking at this saying, there's no way I could possibly work. I'm a surgical candidate, and there's a possibility they'll find that. But my experience is that for people under 55, unless there's overwhelming evidence of lack of function, and maybe getting a functional capacity evaluation from a treating doctor might help. But again, it's just Social Security is that's what they do. I mean, they don't want to approve people early. They're trying to save money. So if I had to guess, based on my experience, this case will be turned down. You should definitely appeal it. And once you hit that year, if you are still either not recovered or the surgery gets canceled, sometimes that happens, then you'd have an argument for at least a closed period. And if the surgery is not successful, then you'd have an argument for ongoing disability. But that's my guess as to what's going to happen. Frustrating as can be, I know. You've got restrictions from your doctor. All that stuff logically makes sense. They should approve you. Hopefully they do, but don't be shocked if they don't, because that's just the way Social Security rolls. Okay. Kevin Johnson, still watching both live stream. A lot of people are frustrated. Yeah, it's really frustrating because they have lost a lot of people. I was reading an article, I forget where the source was, but that a lot of field offices have lost, a third or half of the people. And what they're doing now is they're reassigning people from executive positions to field office positions. And of course, a lot of those people have never done field work, meaning interacting with actual people. They were pushing paper. So it's going to take a while to get those folks trained. But yeah, it's really, really frustrating. I mean, I was looking at some documents today, or yesterday actually, where a client got a letter saying that we see that you've hired Jonathan Ginsberg, a non-attorney. Well, my paperwork is clearly that I'm an attorney, but they that's what they do, and then you've got to get that corrected. So it's a bit of a mess, and I think that where we're seeing a lot longer delays would be at the initial and recon, not so much at the hearing, but initial and recon. And Kevin, you're right. It's really frustrating. If they cut Medicare, I have not heard that that's on the chopping block at all. I heard Medicaid might be more on the chopping block than Medicare. Medicare, I understand, is something of interest to people at retirement age, folks who are, that belong to the AARP, and that's a pretty big lobby. So I don't expect to see much in the way of changing Medicare. Medicaid is a program usually associated with SSI. It is for low-income people. Not much of a lobby there. That has been more on the chopping block that I'm hearing. So it's I would say Medicare is probably not going to be touched if I had to guess. And as far as I don't know that there's any pardon of Social Security there. Okay, Teresa Bond. I've been approved. Great. I'm now awaiting the paperwork to arrive. If I'm working during the trial work period because I have bills to pay, my 9-month trial is the end of June. Is that when I need to quit, or is the trial work period from the onset? No, it's from the onset date of your disability. So if you were found disabled back in, let's say, October of 2024, and you went to work, and you have 9 months from the date of onset. And so once you use up your trial work period months, you're still okay as long as you're under SGA, which in 2025 is $1,620. If you go over SGA, then you get into overpay status. So you can use up your trial work period months without a problem as long as you're under SGA. I will tell you that when you go into work and you've used up your trial work period, even if you're under SGA, now you're a little bit more of a risk for them to do a review, because if they see people who are earning, $1,400, $1,500, which is below SGA on a regular basis, they might look and say, well, this person could possibly work a little bit more and get over SGA. So I don't think there's much of a danger while you're in the trial work period, but once you use up your trial work period months, which again starts as of the date you were found disabled, not the date of payment, not the date of decision, the date of onset that you were found disabled. You're working. Yeah, I think that, and a lot of people do that. A lot of people do work while they're waiting because they have to. I mean, it's I think that Social Security, to their credit, they realize that more people are, having to work because they have to pay the bills, and it doesn't mean you have the capacity to be, earn, what you were earning before, $30,000, $40,000, $50,000. But SGA is about $19,000 a year, not a whole lot of money. So again, if you're earning 12, 13, 14,000, I don't know that that's a big problem, but yeah, you got to be careful about that. All right, Kelly, my client from today. We had a hearing. We had an ideal case. It was a 20-minute hearing, 15, 20-minute hearing. Um, and basically, what she's getting at with the grid rule is, in my pre-hearing brief, I'd referenced the grid rule, which the judge is going to approve the case on. I think I put the wrong one in. I don't remember if I was saying, because she had past relevant work. I think I said she didn't or whatever, but the judge understood that the grid rule applied. Basically, we were able to show that in this case, she was basically limited to no more than sedentary work with no transferable skills. Basically, the judge asked the vocational witness, are there transferable skills from Kelly's past work, which was in the medical field? I'm not going to go into detail about it, but there was no transferable skills. And so, the judge, after taking testimony, and Kelly did a great job explaining in very specific terms what the issues were arising from her chronic medical condition. And I think something came across as very, very credible. The judge, I think, was sympathetic. The judge was very pleasant. And everything just kind of worked out. And like I said, it was a 20-minute hearing. And the judge announced, I'm going to approve it. You'll get a written decision in a few weeks, and that's ideal. And so I know, Kelly, we're going to get you a copy of that, the audio of the hearing, but you did great. I mean, I wish everybody could listen to the way you answered the questions, because it was exactly, very focused on specifics. You answered exactly what the judge asked, didn't ramble about things that were not relevant. And you came across as being a reluctant claimant, somebody who had worked for, 30 years at the same type of job. And in her case, she had worked at a job at a very high-paced company, then went to part-time because she couldn't handle that, and then had to leave that job and went to work for another company, even more part-time. And so again, if I'm, as I always talk about, a big believer in a narrative, and the story we were telling was, we got a person who worked really hard for a long time, had to cut back, then had to go to another company, trying like everything to stay employed, but because of the limitations associated with her symptoms, simply could not do it. She explained it very, very clearly. The judge accepted it, and literally after, I think the judge asked you maybe 2, 3, 4 questions, I didn't submit in my brief. I didn't really say much of anything. Judge went to the vocational witness, and you like judges like that kind of know. They don't waste time. They don't go through the process of going through stuff they don't need to go through. And so again, you get a good judge who understands. And I looked her up. She had been doing this judge had been there for 15 years. She knows what she's doing. And she was very pleasant, not looking for a reason to turn you down. So it worked out great. So you did great, and I appreciate your kind words. Okay. Blue Z, I had my kids' auxiliary benefits phone interview at the beginning of this month. I received the letter. Do you know how long it takes for the back pay to be deposited? I don't. It could be, a few weeks. I know that these auxiliary benefit interviews tend to get delayed, just because it's sort of, they have a lot of other things to do, and they consider auxiliaries less important than the underlying person. I would guess 2 to 4 weeks, but there's just no way to tell. Social Security, it depends on where you live and how busy they are. I mean, again, some field offices are just, they don't have enough people. And the new commissioner, I just read, he issued a statement saying, if we can make do with 20,000 people, we'll do it. If we need 80,000, we'll get it. Of course, Congress has to fund that. And, I think certainly the move is to use artificial intelligence to reduce the need for human participation. I was looking at, there's a blog that I follow, and the gentleman who writes the blog is like, AI is the biggest scam in the world. It's not. I mean, in fact, I was talking to another attorney today who has an AI product. It can be very, very useful. The problem is, AI is it's garbage in, garbage out. So it's very hard. If you've ever called a call center and you answer, the bank, let's say, and it answers and it says, tell me in a few words what you're calling about, and you tell them, and then it, ask, and it just puts you in the wrong place or ask you again. So, I think the, AI that will really be able to respond to specific questions, that's a ways off. We're getting there, but it's certainly not the cure-all. I suspect that what Social Security believes is that a lot of the business that people have, getting a new Social Security card, advising them of new bank account information, can be done using artificial intelligence. Whether that's the case or not, there's going to be growing pains. So we shall have to see. Trish Ward says, hello, everybody. Hello, Trish. Joey Joe Shabadoo says hello. Natania says, happy Wednesday. Vince, you're here early. I hope you're doing well. It's warmed up where you are, no doubt, and good to see you. Andrea Menier, and one of our clients, thank you for all the hard work answering the questions and preparing the recon. Yeah, I mean, I think that, recon is a low percentage approval. I mean, I think 18% of cases that are appealed recon get approved, but we got to go through it. I tell you what I find is I'm doing, when I'm doing my hearing prep, I'm more and more looking at the disability report and the function report that people fill out at initial and at recon that really tells me in their own words what's going on. And again, it's part of that narrative. When I'm writing my brief, I try to incorporate that narrative in there. So, I find it very, very useful. So even though I'm not sure that, Social Security is going to, approve you because of what you write in the adult function report or a disability report, it does help me. And I think it also helps you kind of reduce to words, what's going on. And it really tells me what, you believe is the most important thing going on, which is useful for a couple of things. One is that, when I'm preparing my direct examination, I know what you believe to be the most important factor because you've told me on that report. And if it turns out that that factor is something that I think should be secondary to something else, in other words, let's say that you have sleep apnea and a herniated disc. Well, a herniated disc is going to be more important in a disability case than sleep apnea. So, but if you focus on the sleep apnea, that would tell me in our hearing prep to kind of restructure the way you look at it so that we can focus on the things where there's objective evidence. So it is actually very, very helpful to me. And again, we try to spend time on the recon so that, again, it just tells us more. And I'm also saying, I will tell you, one of the things I'm noticing is that Social Security seems to be looking to approve those stronger cases. People over 55 with something significant, I'm seeing a lot more early approvals. Now, I'm also seeing them change the onset date sometimes to somebody who applied when they're 53 and then they change the onset to 55. We have to make a decision. Do we appeal that to go after more benefits? Every time I've appealed it, I've won, but, I haven't gotten a really bad judge on it. So, the thing that would really concern me would be state agency approves somebody at 55, but we want to go and we appeal, want to go back to 53. When you appeal, you have to appeal the whole case. You can't just say, I'll take what they've given me. I'm appealing the past 2 years. You've got to appeal the whole thing. So then you get in front of a bad judge and the judge could deny you entirely. So you've basically, had a case that was approved and then the judge ends up denying the whole thing. Has not happened, but that's the risk. And I got one right now where they approved the case, but they cut out years of past due benefits, $30,000, $40,000. I'm going to tell my client, look, I mean, that's a lot of money. The fact that they approved you at 55, I think is what it was, says that, there's a pretty good argument you're disabled, and I believe that you are. But there is a risk, not a big one, but there is a risk. Now, I had a case last week where we did that. We got an approval early. My client was getting benefits. We appealed the onset date. During the hearing, the judge was like, well, I could approve it as of the 55th birthday. I'm like, well, Judge, that's what the state agency did. Here's why that's not the case. And the argument we had was that at the time the state agency had approved him, they had a 15-year look back for work. As of now, it's a 5-year look back. So basically what happened was as of 2025, you go back 5 years because the date last insured is in the future. Bottom line is you go back 5 years. to 2020, he had not worked since 2018. So there was no past relevant work. And so I said, well, Judge, no past relevant work. He meets the grid rule. The judge looks at it and says, because he was 58, so it was the light grid rule. Judge was like, you're right. I'm going to go ahead and do it. Judge approved it. My client's going to get a thanks $30,000 check. So you have to just kind of know, kind of what the how the rules work and when that could make sense. Cynthia with an I. Good evening, all. Hello, Cynthia. Mr. P says to Teresa, I'm working while applying too. You got to be careful, because when you're working, realize that Social Security defines disability in terms of whether you have the capacity to be a reliable employee. In fact, on the 5-step sequential evaluation process, the first question is, are you working at substantial gainful activity? If you're not at SGA, but you're working, then, at the administrative level, that's going to muddy the waters enough. Administrative, I mean initial and recon, that will most likely muddy the waters enough so that they're not going to approve you early. So you end up going to a hearing. You may have no choice because you have to feed yourself, but that is the risk when you are working. So, but sometimes you have to. Stephanie says you have to go to court for the grid rules. It depends. I mean, sometimes at the initial or recon, I will make a grid rule argument in the comments section at initial and recon, and sometimes it works. I will tell you that, some of the adjudicators I've spoken to over the years understand how the grid rules work. Others have a general understanding, but not specifically, and especially when it comes to transferability of skills, because, that's where you have to look at the dictionary of occupational titles, and you have to, figure out, let's say that you are a medical transcriptionist, let's say, there might be skills to be a transcriptionist out of the medical field. Okay, that would be where there could be transferable skills. You're a medical sonographer, an ultrasound tech, all right, there's not going to be any transferable skills outside of that specialty. So in that situation, there would be no transferable skills to a lighter exertional level. So, that's a decision that a vocational witness has to make. My point is that when you're at initial and recon, the adjudicators, usually don't have access to vocational witnesses or experts to answer that question, to decide, they sometimes know what the DOT code is, but transferability of skills is a whole different story. And then it's more than just transferability of skills. There has to be an RFC determined. RFC stands for residual functional capacity. So at a hearing, the judge would say, okay, I'm finding the following RFC, residual functional capacity. This person is limited to light work, but no climbing ladders, ropes, and scaffolds, no bending, stooping, kneeling, crouching, or crawling, no bending at waist level to pick anything up. The person is limited to lifting 10 pounds occasionally, 10 pounds frequently, 20 pounds occasionally, but no lifting from the floor to waist level. This person needs to avoid temperature extremes and pulmonary irritants. Well, the judge has just modified the light work, the light definition of work. And so that is the functional capacity. So in a hearing, the judge would say, are there any transferable skills into this RFC? And so that would be a factor the vocational witness would keep in mind. At the state agency level, you're not going to have a state agency adjudicator, really going to find that sophisticated of an RFC conclusion. Maybe that there'll be a doctor who will limit you to sedentary or light, but not kind of modified version of it. So the answer to your question is yes, the grid rules can apply, but if you start getting into some, I'm not going to call them nitpicky, but you start getting into variations of light or sedentary, it's going to be hard for the adjudicators to reach those conclusions. They're not trained or authorized really to do that. So the answer is yes, you can win using the grid rules at initial or recon without going to a hearing. The reality is many times it's very hard to, get everything to line up exactly the way you want a pure, if you want to call it that, RFC. Whereas when you get to a hearing, the judge can modify the RFC, modified light, modified sedentary, and that's where we can get the grid rules to apply. So it's something that I use in my arguments, but it may not always happen. So, and then you factor in that some adjudicators don't fully understand how the grid rules work. So I'd say, it's less likely, but it still does happen. And I've had a number of cases when, and again, like I said, what I find that many adjudicators will do is they kind of, they're not going to delve into modified sedentary or modified light. They're just going to say at age 55, we can approve it because we think the person would be limited to no more than light. But the real RFC is somewhere between sedentary and light, but they're not going to do that at the state agency. They kind of move the age category up to the 55th birthday or the 50th birthday, which is kind of frustrating because, again, it can cost you thousands of dollars. Sarah D. Alongside my chronic conditions, I will need major knee surgery, realigning bone with screws. The healing time can extend longer to chronic conditions. Can the short-term knee surgery help? I think it's all part of the big picture. Keep in mind there's a 1-year duration requirement. So if you have a situation where your medical conditions, your chronic conditions, and your knee problems go beyond a year, then once you have that year, you're going to at least hopefully get that year. And then beyond that, there's a certain period of time until the surgery happens, and then assume 3 to 5 months recovery. And then the question is, after that 5-month recovery from the knee surgery, has your RFC, has your functional capacity improved to the point where you theoretically could do some type of work? Maybe those chronic conditions would keep you out of work. Maybe the combined effect of some reduction in your knee function, standing, walking, kneeling, things like that, plus the chronic conditions could do it. But I think it's all part of the picture. Again, Social Security is going to wonder, what happens after the surgery. In some situations, if it's a judge, the judge is going to say, well, I'm going to only worry about how she's at now, how Sarah's at now, and they can figure out down the road if they want to review her in 6 months or a year to see whether the surgery has caused her to regain some capacity. That level of sophisticated analysis is usually not present at the state agency, but I think, anytime you're a surgical candidate, that helps. I think that shows you've got a serious condition that is not one that's going to get better on its own. And normally, if you have to undergo surgery, by definition, it's pretty significant, and probably in many cases, especially if it's a lower extremity like your knee, it's going to be really hard to do very much because knee pain, it's really hard to do anything. If you're sitting, your knee is going to be bent. It's going to cause you to take, unscheduled breaks to stretch out. If you're standing, you're going to be limited there. Again, you want to quantify that, but absolutely it helps. No question about it. Natania, thank you for the tip. Thank you very much, Natania. Really appreciate that. Hope you're finding this useful. And again, I really, really appreciate the kindness. Like I said, it will, hopefully get, help. I always tell you all that my son does the videos for me. He edits my videos. I've taught him how to edit videos. And so, I pay him for it, but I also, take him to lunch periodically. So the tips and things like that go to that lunch fund. So he gets, he gets a nice sandwich out of it. So on his behalf, we appreciate it. Okay, Joey. I'm 53 years old, have a 10th grade education, obese, diabetic, anxious, and depressed, COPD, asthma, many others. You think of what my hearing. It just depends on what the medical record says. Now, again, at the grid rule, you have less than a high school education. So you've a limited education that will fit you into more grid rule categories. 55, 56 is better than 53. But again, if you are limited to sedentary work, you've got a decent shot. Obesity is no longer a listing, but it is a factor because obviously if you have significant weight and your BMI is way out of line to your height, then it's going to be hard, especially if you've got medical support to this effect. It's going to be very hard to be on your feet for 6 hours, which is what would be required by light. Diabetes. Do you have symptoms from diabetes? Frequent urination would be one. Are you insulin dependent? where you have to take breaks to inject insulin? Is your diabetes brittle, where your blood sugar gets out of control, goes too high or too low? So these are chronic conditions. How severe are they? Anxiety and depression, I will tell you in general, unless it is severe, and severe meaning that it is, you're on serious psychotropic medications that have significant side effects, you've been hospitalized, there's suicide attempts, there's multiple medication trials, mild to moderate depression and anxiety are not going to really move the meter. They can add to things, and they may help eliminate any transferability of skills because of difficulty with focus and attention and being able to make adjustments to other jobs. But that I think that the diabetes and the implications there, the obesity, the COPD again is going to eliminate jobs where you're going to be around pulmonary irritants. But I'll tell you, there's a lot of people with asthma out there. You don't win cases generally on asthma unless it's really, really severe. You don't win cases on, mild to moderate anxiety and depression. So, the combined effect of all these things, could put you over the finish line. Do you have a doctor who's willing to say that, to basically say that the combined effect of all this would just make you not reliable or limit you to, sedentary work, which again, and with no transferable skills would mean that you would meet the grids. So I don't know. Again, you've got a lot of things going for you, but without knowing about the degree of severity, it's impossible to really say. Teresa says, good luck while waiting. Thank you. I agree. Andrea Minier, if my functions have declined since the surgery with myelopathy and further treatment with a neurologist, can we ask for special consideration of wake? Now 56, 55 when filed. Yeah, I think that, if you have a failed back surgery or a surgery that was not successful in restoring function, and you're 56 or 55 at onset, then, the light grid rules are something that would be in play. And I think that, it's not about matter of special consideration. It's about asking them to look at the grid rule. And what I put on there would be, please analyze this claim under grid rule 202.06, which basically says if you're limited to light work, high school education or more, past work but no transferable skills, you're still disabled. I win a lot of cases on grid rule 202.06, and that's probably, again, I don't like to discuss individual cases, on a public forum, but in general, based on the facts you're telling me, that's an approach I would most likely want to take. And that would be one of the arguments. That's not the only argument I would make. You would still argue that, there's no functional capacity, for even sedentary work, but even if limited to sedentary or light, you'd still be disabled. And again, a person who's had failed or non-effective back surgery, is probably on long-term pain management. It's pretty, I would say easy, but it's a logical conclusion to think that they would have trouble even doing a light job, which is standing and walking 6 out of 8 hours, lifting 10 pounds frequently, 20 pounds on occasion. And again, that's probably where we're going to go with this. Joe, good evening. Doctor finally recommended medical device and equipment after years of having symptoms. We're going to send another ALJ with that, with a need, but timing. I think that always let the ALJ know about anything new. And again, if it's a medical device, spinal cord stimulator, insulin pump, or whatever, though that's usually an indicator of severity. So yes, I would let the judge know. Now, the other question that you got to ask is, if you're getting this, determination that you need a medical device now in 2025, but your onset was 2022, the risk you run is the judge could say, okay, I'll find you disabled now as of the time the doctor recommended this device, but not going back 3 years. There could be a date less insured issue. And of course, the money would be greatly reduced. So I still would put that in the record. And my argument would be that it's probably been needed for a long time, but you finally got the doctor to agree to it, perhaps because of insurance issues and so forth. But just be aware that you want to get it in, but you also want to make the argument that even though this is being done now in 25, the need for this really goes back, 2, 3, 4 years, just so that they know. It doesn't mean they're going to agree to that, but that's something that you just want to make sure you at least put in there. You're welcome, Andrea or Andre. I'm not. Some people call it, they Andrea. Some people call it Andrea. Some people call it Andrea. I know my daughter has a friend who's Andrea. So sometimes, you have to tell me what you prefer. But that's a name that sometimes people pronounce differently. Mr. P, I hope we can win this time and quick. I hope so too. Cindy G says good morning. So Cindy, you must be out of the country because your comment was posted at 8:35 p.m. my time, which says to me that you're probably not, in the States. So if you're overseas and it's morning, tomorrow morning, good morning to you. I think I told you all I had a case. My client was living in Vietnam, and we won the case. And Vietnam is literally 12 hours different from Eastern Standard Time. And so it was, 8 a.m. my time, and it was 8 p.m. his time. And so, worked out fine. But it was just very interesting that, it was nighttime for him, and for everybody else it was the morning. But, it worked out fine. And, it would be more of a problem if it was like 3 a.m. because, that would be hard to get up and get ready for a hearing with that. Rebecca Taylor. What about the ones over 50? If I have a disability, have high school diploma, the grid? Yeah, absolutely. In fact, let me pull up the grid so I can. I do this typically. I did this a good bit a while ago. Let's just take a look so you can see, because again, the grid rules are really, really very valuable. So let me present and show you my screen here. Okay, so here are the grid rules. You can see. And you see, this is my website called gridrules.net. And so when I call the sedentary grid, what I'm saying is when your maximum work capacity is limited to sedentary work, which is sitting 6 hours, standing and walking 2 hours, lifting 10 pounds occasionally, 5 pounds frequently. So if you look at this, at age 55, if you're limited to sedentary work, you're a high school grad or more. That means you could be a college graduate, a graduate degree, but no direct entry into skilled work, you can be found disabled. 201.04, 55 plus, high school graduate or more, unskilled past work or no past work, again, nothing in the last 5 years, then you would be found disabled. So even if you have a high school degree or a college degree, it doesn't really matter. When you get to light, which means that you've got even less capacity, you'll see there's a lot more. And again, I mentioned 202.06. I use this a lot. A person who's 55 plus, who is a high school grad or more, again, maybe went to college, for a couple of years, or a college graduate, or it could be a doctorate. It doesn't really matter. It's all considered high school grad or more, but no direct entry into skilled work. No, you see here, no transferable skills. So you may have, let's say a person has a doctorate in physics. I'm just, kind of hypothetically speaking, but there's no transferable skills. What is, being a person knowledgeable in physics, maybe you could be a teacher, but again, if you can show, if the RFC provides that you're limited to simple 1 or 2 step jobs, you couldn't do that. So even if you have a doctor, a PhD, a master's degree, it doesn't matter. You can still be found disabled. So you can see there's a number of these where, if you're 55 plus and you've got no transferable skills or no past work in the last 5 years, you could be found disabled. At 50, it's pretty hard to make that work. At 50, if you're limited to sedentary work, which again is, I think I misspoke. Being limited to sedentary means it's you are really, that's a pretty significant limitation. That you can only do sit down type of work. At 50 to 54, no transferable skills, 201.14, you can be found disabled. So, basically what it's saying is even if you can do sit down work, you're still disabled. The light grid says even if you can do light work, you're still disabled, assuming no transferable skills. So the bottom line is you're over 55, you have a lot of grids that apply. There's even one here at medium, which again is that's lifting 20 pounds frequently, 50 pounds on occasion. If you have no limited education, 10th grade education, no past work, and you're 60 years old, you can be found disabled. Again, you see it's pretty limited, but medium work means you're pretty strong. Okay, you got a lot of capacity, but you can still be found disabled even if you can do medium work. So, it's a not a significant limitation. Light is significant, but not as you would have more capacity doing light work than sedentary. If you're limited to sedentary work, that's going to mean you're pretty limited, because that's all you can do is sit down work. When you get to light work, it means you've got strength, and you get to medium, you've got even more strength. So again, if you have a doctor who limits you to sedentary, a lot of the grids open up, is my point. Okay, so I hope that makes sense, that if you're over 55, over 50, look at the grids, but over 55, absolutely. Peter, I recently won. SS held back 25% for lawyer fees. I have an appointment with Social Security Auxiliary where they hold back 25%. Only if the total fee for your case, for you and your auxiliaries, cannot be more under a fee agreement than $9,200. So if the 25% for you was $4,000, and so that's obviously less than $9,200, and then there's another, a bunch, another $5,000 or $6,000 payable to your auxiliaries, and 25% of that would not add up to $9,200, and yes, your lawyer will get paid a percentage of the auxiliary benefits, but you don't get paid 25%, up to, let's say you get the full $9,200 and then you get another $4,000. It doesn't work that way. It's the total for everybody in your case. It can add up to no more than $9,200 under a fee agreement. Leanne Belcher. Okay, my representative called DDS, and DDS said my claim made it through quality review and it was approved. That was April 24th. Still hasn't made it to, see if you get any more here. Any more to the local office, anything to worry about. I don't like to tell people not to worry. What I would tell you is that, getting sometimes these things processed can take time because of these staffing problems. It always makes me nervous when something is going to quality review for analysis, because it could be they look at it and say the state agency screwed up and we need to take another look at it. That doesn't happen a lot, but it is possible. So, April 24th is a long, it's a month, it's been a month. I wouldn't worry too much about it, but I think you get to 2 months, I would probably be a little concerned. That would be a time when I would have you contact your U.S. Senator and just say, look, my case, they were telling me it's been approved, but it's stuck at quality review. Can you make a phone call and get this thing moving? And that might be something to do. Maybe not quite yet, but maybe in a couple of weeks. Which is better, SSI or SSDI? It's not about being better. I mean, SSDI is a more robust program in that there's no means testing for it. SSI, basically, if you have assets or household income, like a spouse, that can offset your SSI. If you have, again, assets, and there's certain things that don't count, like a house, and I think a car, but let's say you have money in a retirement plan, that can offset your SSI. So it's a lot easier to see your SSI reduced because of income or assets. Let's say you're married and your spouse works, they use what they call the deeming rules, and they reduce your SSI. SSI, in my opinion, will keep you in poverty. So I think, if I had to say what's better, I would say SSDI. SSDI is based on your earnings record. The amount that you will get is usually going to be higher. SSI is typically capped, and I think it's $1,050 or something like that, whereas SSDI could be $3,000 a month. SSDI does not have an asset problem, so you could have $100,000 in stocks, doesn't affect you. Your spouse could be working and making $500,000 a year, doesn't make a difference. So I think SSDI is a more robust program. I hate to use the word better, but it's certainly a program that has less things that could go wrong. Does a hospital stay, asked Rob, help your chances in depression? Absolutely, because that is, in my opinion, an indicia of severity. If you've been hospitalized in a psych hospitalization, that says it's serious enough where the doctor couldn't treat you outpatient. And that says something is pretty significant. So yes, that is something that makes your case, in my opinion, significantly stronger, especially if it's recent. If it's 10 years ago, not so much. But if it's recent, you've had 2 or 3 hospitalizations in the last 3 or 4 years, that says that you've got depression, anxiety that is not medication responsive, not under control. Ladies, JJ, self-care, and more. Still waiting on a hearing date. Will there be a way I won't need to get a hearing and get approved? Already had neck surgery, just waiting on the date. I've been working, suffering. Let's see here. Can I apply for financial assistance? I'm waiting. Okay. So, I do a pre-hearing brief on almost every single case. And I've had a few in the last few months where, I get a phone call the day before the hearing and the judge is like, there's nothing for us to talk about. I'm going to approve the case. My case today, that could have happened. It didn't, but it could have. So it can happen. And I think certainly, if you're represented and your attorney can make a compelling pre-hearing brief and argument, then it's possible they could do without a hearing. Many judges want to they want to listen to you. They may have a few questions about things in the record. Or they just don't have time to really evaluate things. I've had judges tell me that they don't look at the file until the weekend before the hearing. So in that case, you may not. Look, I have a hearing tomorrow where, and I'll try to make this very brief, but my client had gone to her previous hearing and was found limited to sedentary work. And at the time of the previous hearing, she was under 50. And now, she's over 50, maybe even over 55, I don't remember. But there's a law in the Fourth Circuit where she is, in Virginia, that says that a judge in a second hearing has to look at the prior hearing and, basically is going to be bound to the RFC determination in the previous case. In that case, she's limited to sedentary work. Well, there's no past relevant work. She grids out. So in my pre-hearing brief, I said, look, by law, in the Fourth Circuit, there's a previous determination that she's got an RFC at sedentary. There's no past relevant work. She grids. And unless the judge here wants to decide that she has regained or obtained more capacity, she will win. That case should have been approved early. I submitted my brief last week, haven't heard anything. I'm hoping when we get to the hearing that the judge, says, Mr. Ginsberg, I read your brief and you're right, and we don't need to go any further. Hopefully that will happen. But again, you just can't force, judges aren't going to be, you can't force them to read anything. They're busy, and I respect that. But yeah, it's possible. And you want to give them an opportunity in a pre-hearing brief, but it doesn't always happen. Rodney is one of our old clients. Good evening. Looking forward. Thank you, Rodney. I appreciate that. Good to see you. And I appreciate you tuning in almost every week. MT, been almost 2 years since I filed and not received one decision. Have an attorney, got my U.S. Senator involved. Hopefully you'll hear something soon. So you're saying you filed 2 years ago. You've not gotten a decision on the initial application. That's a real concern for me, because what that says to me is it's very possible that they made a decision, you never got it. In which case, they see you as being denied and you don't know about it. And so now you're going to have to undo that by trying to convince them that they didn't properly notify you. And, their attitude is, we mailed it and, we assume you got it, and, you can't prove you didn't get it. How do you prove a negative? That's the problem. You can certainly make the argument that you never got it. And I've had that happen a few times. And we've asked for good cause, but there's no guarantee they're going to give it to you. I think it was a wise thing for you to do, to contact your senator, because again, and maybe, your attorney has been in contact with the state agency and has confirmed that, in fact, your case is still active. We've got a couple like that where we have a couple actually where it's a paper file. In other words, right now, Social Security is paperless. Everything is done electronically. But there are a few cases, 3%, 2%, where for some reason they have it flagged not to accept electronic filings. So we have to do it by paper, which means we physically have to fax or mail in appeal, disability report, and things like that. And it takes forever. It takes, and what'll happen is it will show, you go into your My Social Security statement, your system, and it'll say case closed. And in fact, the case is active, and we'll call up the state agency. Oh yeah, it's still active. I have a gentleman who's a frequent guest or frequent visitor to this live stream, and he's calling the Social Security officer saying your case is closed. We're calling and we're saying, no, we filed a paper appeal, and we know they acknowledge it, but because it's not electronic, we can't find it, or they can't. There's a disconnect between what's going on in one office and what the reporting people say. It's very frustrating for everybody, but there's nothing we can do about that. Again, this case I had with the gentleman, we appealed his onset date, or we appealed a change in onset date. We appealed essentially a favorable decision. We had to do it on paper. And so we did it. And for the first 8 or 9 months, they showed it as being closed. And then finally, the paper caught up with the system, and they showed that the case was, being appealed. And in fact, we got a hearing. I had a hearing last week and I won. But it is really frustrating, really frustrating. Can you apply for financial? Yes, assuming it's, again, SSDI. Yeah, you can. Now, there is a question sometimes people raise, can I apply for unemployment? And the issue there is that unemployment, you're saying I'm ready, willing, and able to work. So can you apply for unemployment? I take the position that if you apply for unemployment, you're saying I'm ready, willing, and able to try to work. I'm not a doctor. I can't make a conclusive determination that I can work, but I'm willing to try to work. And if you, in fact, do work and you're only able to last for 3 or 4 weeks, that looks like an unsuccessful work attempt. I think that helps your case. What you got to be careful about is if you go back to work and you stay for more than, say, 4 months, it looks like a successful return to work and your case will disappear. So you don't want to be in a situation where you work long enough to disqualify yourself from step 1 of the sequential process. Are you now working, but you're not making enough money or working long enough to support yourself? Then you got to start all over again. So you just got to, that's where, talking to an attorney would be helpful. I would tell somebody, these are the numbers you got to be aware of. And again, if you make it more than 4 months, let's say, then you got to make a decision. Are you going to pursue disability or work? I would always tell somebody to pursue work if you can do it, but don't, the worst thing you can do is stay at a job for 7 months, which is, the 6 months is sort of like the rough time limit for successful work, but you leave after 7 months. There are some arguments you can make, trial work period, things like that. But bottom line is you're going to probably end up starting over again. And it just makes life a lot more difficult. So I would probably tell you to, just be real careful about working. But again, you'd ask about financial assistance. But yeah, that's SSI could be a problem because that can be an asset or earning that would reduce your SSI. SSDI, no. I think Rob already answered that. Hospital stay, it does. Yes, it does. I think I answered that before. Stargirl says, on the work history report, how should I answer the questions about past jobs of a BA and a few highly skilled jobs? Would that hurt your chances? I mean, it depends on, it is what it is. I mean, the bottom line is if you had skilled jobs, you got to put them down there. The question is, are those skills transferable? Or an alternative, do you have a medical issue such as, pain medications or anxiety and depression or something that would reduce your ability to use those transferability skills because you can't focus and concentrate, even sleep apnea, where you get non-restorative sleep. So I think that you want to describe what you did. Don't overstate what you did. Just describe, what you did, for the most part. And yeah, I think that it could be something that could end up, making it a little bit more difficult because, yeah, there's a bias in favor of people who have less than a high school education, or high school education. But, again, having a college degree and having skilled work, um, many times I have people that meet the grid rules with skilled work because I'm able to eliminate transferable skills because of medication, because of depression, anxiety, chronic pain, things like that, that, reduce transferability, or that your skills are so specialized to your particular industry that, even if you have transferable skills, they only transfer so narrowly that they're not applicable sometimes someplace else. But yeah, I would just be very, just describe your work very matter of factly. In fact, take a look at the DOT. Go to occupationalinfo.org. I'll put that in the comment here. The DOT is occupational. Let me see here. Info.org, and look up your job. Look it up and see, what is the SVP? That's the skill level. What is the exertional level? Is it sedentary, light, medium, or heavy? And it might give you some sense of whether they're transferable skills. There really are no. I mean, you could ask Google or ask Gemini or something. Which, by the way, some of these AI tools are pretty incredible. And you might look at some of those and ask, in a Social Security context, are there transferable skills from being a dental hygienist? And I'm not saying it's going to be binding on Social Security, but it gives you more information than you just would have using Google. So, check that out. But I would look. But the BA and the skilled jobs doesn't disqualify you. It just makes it a little more difficult, makes it a little bit more work. Anthony Jernigan, fully favorable notice. Alleged or onset date, February 18th of 24, waiting on notice. Will back pay from March, date I started getting benefits. So if your onset date is February of 24, the 5-month waiting period will run from the rest of February. You don't get paid for partial months. March, April, May, June, July. Your first past due payment would be for August of 24. So the lump sum would be August of 24 through May or March of 25, and then you start getting monthly payments then. So that's how the past due is calculated. But for SSDI, there's a 5-month waiting period. Does not include partial months. For folks desperate for insulin or lung meds, find your local free clinic. Good night, could you? Yeah, I think that's, Russell, you make a really, really good point. And that is that I have a lot of people who are diabetic or who have breathing issues, and there are low cost or free clinics that will dispense insulin, will dispense COPD medications that at least keep you somewhat stable. I know that politically, insulin in particular has been a really big. There's been a lot of news about it. I don't know if y'all remember, there was a couple of years ago on the news. There was this gentleman who bought a company that made some sort of a fast-acting insulin pen, and he jacked up the price because he could in the United States, and there was a lot of pushback on it, and I think eventually it came down. But yeah, I think that if you don't have money, it's really important. And actually, Russell, you bring up another point, and that is that Social Security looks at it and says, "You're not going to the doctor. We're assuming there's nothing wrong with you." So you got to find a way to go to the doctor, even if it's the free clinic, because even if they're just giving you medication, that at least supports your argument that you need medication. And then your symptoms, obviously it would be helpful to have a doctor talk about them. But if you're on insulin and you have, so let's use this as an example. You're diabetic, you're on insulin, and you have a blood sugar diary where you take your blood sugar readings 2 or 3 times a day, and it shows that your blood sugar is consistently in the 200 to 300 range. And then 2 years later at your hearing, you testify you have numbness in your hands and your feet. Is it as good as having an endocrinologist talk about it? No, but it's consistent. And having, blood sugar readings of 200 to 300 and complaints of numbness and vision problems and evidence that you're getting insulin, from a free clinic might be enough with some judges to, for them to find that you are in fact disabled. So you got to work with what you got. But yeah, that's actually very good advice, Russell. Thank you. Going to have to go to a hearing all alone. Where I can find Sean talks about. I'm not going to hear because no lawyer wants to help. And and let me just address that, because there are times when it's going to be hard to find a lawyer. If you are 38 and you've got fibromyalgia, hard to find a lawyer. Lawyers get paid on a contingency, and unfortunately, certain cases you just know are going to be really, really hard to win. I would talk to legal aid. My channel has a lot of things in there. You could look at it, Ginsberg Law. I got 400 videos. Walter Knott's channel has I don't know, he's got 5, 6, I don't know, maybe even more. He's got a bunch of videos. There's a bunch of people out there. I know Anthony Reeves. I mean, he's now a judge, but Anthony had a channel, and I think it's still up there with a bunch of videos out there. A woman named Sharon Christie, who is a nurse. I think she's merged her firm or maybe retired, but she's still out there. So Chad Brown has got some nice videos. So there are some people out there you can look. And I would also tell you, again, as crazy as it may sound, go to ChatGPT, go to Gemini. These are all free tools, and say, I've got a hearing based on, fibromyalgia, based on lupus. I'm 38 years old. What are some arguments I can make? And see what it comes back with. At least gives you some structure. There are some free resources for functional capacity forms. I know I've put this up here before, that you can get your doctor to fill out. Let me put a couple of those in the notes here. Let's see here. Mike Merberg has some free ones. I'm going to put that in the comments here. So what you might do is download a functional capacity form, and see if your doctor will fill it out. There is another really good resource when you're doing it on your own, called let's see here, how to get on.wordpress.com. I'm going to put a link here. This is a person who's got a lot of information about doing it on your own. In fact, she references me in there. I think it's a she, references me in there at times, some of the videos I've done. It's going to be hard. I mean, I'm not going to tell you that, you go to a hearing, it's going to be difficult, because you're not going to know what to do. The fact that an attorney wouldn't take your case probably means that it's going to be a more of an uphill battle, but do your homework, and again, use all the free resources at your disposal to come up with an argument. The main thing I would tell you is that the real issue in a disability case is whether you have the capacity to work. It's not about the medical, it's about how the medical problems you've got impact your work capacity. You want to be very, very specific. I can sit for 20 minutes. I can stand for 10 minutes. I can walk for 30 feet. I can lift 5 pounds frequently. You don't want to stay not very much, not too far, things like that. You want to be very, very specific, and literally, make a list of all the things that you cannot do, so that you can tell the judge, these are the things I cannot do, and tie them into your underlying medical condition. And yeah, it's going to be hard. I'm not going to tell you it's not, but the more you prepare yourself, and again, look at the How to Get On. It's got some really nice stuff there. Look again at my YouTube channel. Look at Walter's. There's a bunch of people out there with some information. Don't get overwhelmed, but just do the best you can to prepare. Cassie Marie, have you ever had a client win an appeal without going back to the judge? All right, so I think what you're getting at is that if you lose at a hearing and you go to the appeals council, can the appeals council grant an approval? And the answer is yes. They don't do it very often, but they can. Same with the district court. They will typically refer it back with instructions. And I know we had Adriana De La Torre on last week to talk about the appeals process a little bit, but the appeals council will send it back to the judge with instructions. Sometimes some judges kind of read between the lines, read the tea leaves, and if the appeals council felt it was strong enough to send it back, they're basically saying to the judge, approve this case. Some judges get that, sometimes they don't. I'm a big believer that if you can come up with a written argument in a pre-hearing brief, a request for an on the record, that's going to greatly improve your chances at an approval, without a hearing. But I think a lot of people get very focused on trying to get approved without a hearing. It doesn't happen many times, not because the judge doesn't want to do it, but because they're so busy and they're so short-staffed that they don't have the time to really review it and to make that decision. It's easier just to listen to you for a few minutes and then give it to a writer and approve it that way. I think it's more that's the problem. That's the issue more so than you're not wanting to do it. All right, so I think I've got this on the crawl. I'm going to put on here the crawl for leave me a review. I've had a number of people leave me really nice reviews over the last few weeks, and it really does, as Christina mentioned, it really helps me because people turn to reviews now when they're hiring lawyers, and so yeah, getting people that reviewed me that were my client that we won, that's great. Or I've even had a few people that we didn't win, but they appreciated the fact that we gave it a real strong try and that I was there for them. I got some nice reviews there too. I mean, so obviously I much prefer that we win, and fortunately we've got a pretty good track record. But I've had people say, look, the videos, I didn't use Jonathan, but the videos were very, very helpful to me in making my argument or preparing my hearing. Or people say, I saw the live stream and this was very helpful. So anything that you can do, if you're willing to do it, that would be really, really greatly appreciated, because I just it's business, and there's a lot of other people who do this, and I try to share what I know. Alicia asks, if the ALJ, Alicia is one of my clients, decides to approve a case without continuing to the hearing, is always, not always, usually it's going to be within a week of the hearing. Not always, but usually it's because, again, they don't typically look at the file I literally had judges tell me, on a hearing on Tuesday, they looked at it on Saturday. So it's just because they're not looking at it soon enough. Again, that's a little different than it used to be 15 years ago, where I'd submit a brief and the judge would look at it and I might get an on the record decision much earlier. But I'm submitting my briefs a week, 10 days, 2 weeks ahead of time, and every once in a while, but a lot of times it's going to be a couple of days before the hearing. When should you receive your functional report questionnaire at Recon, or do I download and fill out? I would just tell it, download and fill it. You're going to get it. Just fill it out. Download it, fill it out, and send it in. You're going to get it, so you might as well get it early. So, total analysis. One person could not get an attorney. A lot of back pay, but I understand. Take it all. I guess we're going to go ahead and functional capacity. I put in the the comments where you can get free forms. Where you get a functional capacity evaluation, typically you go to a physical therapist, and the therapist, they'll do a 1 or 2 day functional capacity evaluation. It'll determine whether you are, at less than sedentary light. I will tell you, one of the issues there is if you go through that, you got to submit the report. You can't leave it out. So if it comes back, you can do medium work. You can't leave that out. But that's how you get one, and that could cost you $500-600. The forms I just put in the comments, you can get for free. So you can use those for free. 2 sources of getting them for free. No Sky says, good evening, No Sky. And Russell says that free clinics often have social workers that can assist with disability. They can, sometimes social workers know a little bit about Social Security disability, and sometimes they don't. The other thing I'd be real careful about, I've discovered this. Sometimes these social workers will file a 1696, and I've got to get them to withdraw, because if they don't withdraw, I can't get paid. So I would, if you get a social worker, ask that person, will you cooperate if I get an attorney down the road? Will you withdraw in writing so that I can, get an attorney? Because otherwise, I'm not going to get. You can't get an attorney to take your case if there's another 1696 in there. I want to pay for an independent FCE, build my case. Well, again, you don't need a lawyer. I mean, again, a lawyer is going to have an idea as to, what a good argument would be. Again, is it a grid rule argument? Is it a functional capacity argument? Are you basically on your FCE? what we do is we put it all together and we make an argument. And again, I'm a big believer in telling a story, telling a narrative. And, hearings last 45 minutes, boom, 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 boom. So, I'm not wasting a lot of time. Just for example, the preliminary part of the hearing, the judge says, will you waive a formal reading of the issues? Well, what the judge is saying is I could read a 2-page statement that's going to take me 7 to 10 minutes describing the legal issue at stake, or have you, Mr. Attorney, explain to your client that the issue here is about functional capacity, about capacity to work. Just things like that. I think judges don't like pro se cases because it takes a lot longer. They're on a 45-minute calendar. If they're spending 20 minutes doing preliminaries, it's hard to make that work. So, but again, if you can't get a lawyer, you can't get a lawyer. But you can do your own FCE. If you can't get a lawyer to do it, go find a physical therapy office that will do them, and that's what I would do. Me Heidi says, y'all smash the like button. 101 of us watching, only 26 likes. Okay. There are 138 people watching. So yeah, I appreciate that. Smash the like button. My mom used to say, mash that button. My mom was from Atlanta, and first generation from Atlanta. And, growing up, I didn't really hear a Southern accent because she was my mom, sounded normal to me. And my wife is from New York. And so when she met my mom, she's like, your mom has such a thick accent. And I'm like, I don't hear it because I'm just used to it. Because she'd go to the elevator, she goes, mash that button. So it's just things that, and I, I never really had one because I grew up in Atlanta, fairly cosmopolitan. And I, went to school in New Orleans with a lot of people from up north. So I never really had a thick accent. I can turn it on if I need to. If I'm in the right courtroom, I can turn it on, but I don't have a really thick accent. But it's just funny when you say smash that button. That's a kind of a Southernism, I guess you could say. Sue Odachowski, I hope I pronounced that correctly. You applied 4 years ago. Still waiting for a decision on recon. Again, like the gentleman who's waiting 2 years, that is a red flag. Something is wrong. I mean, it shouldn't take that long. You got to contact your U.S. senator. If you've got an attorney, you need to have that attorney call. Dollars to donuts, they made a decision, you never got it. And you're sitting there thinking, I'm waiting, and they got your case closed for 2 years. Whether you can get it reopened, different story. But I would not just sit there and keep waiting. I would contact your U.S. senator. I would contact, if you got an attorney, or contact the state agency adjudicator, last person that you heard from, and see what's going on. But I'm telling you, when I see somebody tells me 2 years, 4 years, that says to me they made a decision, didn't tell you. And that's just what happened. With the new administration, all the new AI stuff, could buying a firearm cause a CDR to lose? Nothing that I've heard of. I've not heard that at all. I don't think that there's been any discussion that owning or buying a firearm could cause a CDR. I mean, I guess, and I don't think that they share information, if that's what you're asking as well. Now, if you're a hunter, and you go through a CDR process and they ask what you do, functionally, and you say, I go hunting every weekend, is that an activity consistent with somebody who is disabled? Maybe not. If you go to the range, there's a gun range not too far from me. I go every couple of months, and holding a gun with a kick, it's physical. I mean, this is not something you can do if you have very limited physical capacity. You're standing up, you're holding something with a kick. If it's a shotgun or something that's got a big kick, I mean, you could make an argument that using a gun is an activity that is maybe not entirely consistent with sedentary or light work. Now, admittedly, if you go to the range once every 3 or 4 months, or you go hunting and you're in a blind, or you're sitting, may not be a big issue, but it's an activity like riding a motorcycle, something that is not entirely consistent with disability. But simply owning a gun, I don't think is an issue. Look, I talked to a client the other day who, used to love to ride motorcycles, and new client, and she said, I've got my Harley in the garage, and I just can't bear to part with it. Hadn't ridden it in 3 years, but I own it. So, you know, what I would tell her, I said to her is, look, I don't think it's a problem if you don't ride it. The issue is the judge going to believe that you kept a functioning motorcycle in your garage for the last 4 years and never got on it? Maybe yes, maybe no. But if you sold it, it's going to make you more credible. If you said, I had this motorcycle after a year and a half, I realized I couldn't ride it anymore, I sold it. Okay, that kind of makes sense. But holding on to something you can't use, does that really make a lot of sense? So I think with the gun, the same kind of thing. What are you using it for? Now, again, I've never had a hearing where anybody says, do you own a gun? Um, if the medical record says this individual, told me that he or she goes hunting every other weekend, the judge would ask you about that. But simply owning a gun, Department of what is it? Explosive firearms, whatever, the ATF, alcohol, tobacco, and firearms. They don't report, to my knowledge, to Social Security. So owning a gun, registering a gun or whatever is not going to reflect on your Social Security case unless there's evidence that a judge might want to, talk about that because it's in a record there. Okay. Okay. So, and again, this is an example. Kelly, we had our hearing today, and the judge said at the end of the hearing, I'm going to find you could do sedentary work, and the grid rule applies. And so what Kelly heard was, you can do sedentary work, therefore you lost. And I said, no, that means that the grid rule applies and we won. So, I'm going to download, it should be ready tomorrow or Friday, a copy of the audio from the hearing, and you listen to it again, you'll see. But if you look at the grid rule, you will see that a person, we can do that in real time here. Let me hit present, share screen. Okay, here's the grid. Okay, so I think at the sedentary grid, if a person is 50 to 54, and a high school graduate or more with semi-skilled work that is not transferable. So that's our case here. Kelly had a skill, but it was very narrowly tailored to her occupation, did not transfer, high school grad or more, no transferable skills, boom, she is disabled. That's the case will say she is approved based on grid rule 201.14. And that's what's going to happen in this case. But yeah, it's a little scary when the judge says you can do sedentary work, but that's a good thing in this case because you meet the grid rule. Okay. Wayne, I spoke earlier about my claim surgery in July, make 11 months. You said they would look at like a year. Well, again, I think that, normally Social Security will assume that it's going to take at least a month or two to recover from a surgery. So I think you are pretty good if you have a surgical order or you have a condition that was consistent with a surgical order going back at least a year, you got the 12-month duration. So again, you want to be found disabled ongoing. Once you hit that duration, again, that's what they call closed period. The issue is that at the state agency, that's more of a judgment call. Did your disability come to an end? So the state agency is probably not going to make that call. They might find that you were disabled for that year, but knowing what to do after that, they're not going to know what to do. That would tell me they're probably going to deny it. And then you get into recon, maybe the recon adjudicator might say, okay, we're prepared. And they might even call you and say, will you take a closed period? We think you may have improved. You may say no, then you go in front of the judge. But where you probably want to end up is, I need ongoing benefits because the surgery did not improve me to the point where I'm able to return to work. Again, anytime there's got to be judgment calls made, anytime there's got to be discretion used, that's not a good thing for the state agency adjudicators. They need things in black and white. You're light, you're sedentary, but when you have transferable skills, have you had medical improvement? those are things that it's hard, and it's in the middle of a case. It's hard for them to do, in my experience at least. Um, let's see. My case is ODD. I'm assuming that's a mental health case, oppositional disorder, but very winnable. I can't work, haven't worked, I'll never work again. How can I improve this? Doctors want to help. No one has an SSI or an FCE. Well, they don't send you for an FCE. They'll send you for consultative evaluation. If you've never worked, that means you're probably SSI only. So that may be part of the reason you're having trouble finding a lawyer, because many lawyers don't want to take SSI cases. If you're married, if you have a household income of some type, that would offset your SSI. If you have assets, that could offset your SSI. So it may be that you've got lawyers looking at it saying you may be disabled, but because of offsets to your SSI, there'll be no money here, or there'll be so little money it's not worth it. That could be what's going on here. And if your doctors don't want to help, that's a problem. I mean, you need to have a treating psychiatrist, really, in any mental health case. And again, I'm assuming ODD is mental health is what you mean. You need support from a psychiatrist and or psychologist. The indicia of severity I look for would be failed medication trials. You go from one medication to the other and nothing seems to be working. Inpatient hospitalizations, suicide attempts, statements from former coworkers. You don't have that, talking about some of the issues you're having, even statements from people that know you, talking about some of the issues you're having. But yeah, it's going to be hard to do much without support from your doctors. Now, again, you talked about an FCE. If it's not physical, and again, maybe I'm going to make sure I'm not. Let's see. Okay, ODD. I mean, that's according to Dr. Google, oppositional defiant disorder is a mental health condition. So doing an FCE, a physical FCE, is not going to help you. Getting a psychologist to do a full scale analysis. Yeah, you could pay somebody to do that. Are they going to be able to, A, reach a conclusion about your vocational capacity, and B, without ongoing treatment, is a judge going to find that persuasive? Because, a report from a one-time visit from a doctor, is only not going to carry that much weight. If it's, a doctor who treated you for 3 or 4 years, much more weight. So I think that those are the, it's hard to find doctors who will help you. And that's mental health. That's actually, I understand. Teresa Bond, what auxiliary would be like children typically, or it could be a spouse, a dependent spouse. So let's say you have, to make this very, very general, when you apply for benefits based on your earnings, SSDI, you have an amount that's based on a calculation of what you'll get. There's also something in there called a family max. They have something called your PIA, which is your primary insurance amount. Then you have what they call family max, which basically says this is the most that your family would get. So if you have like 2 children, typically the auxiliaries will get a benefit equal to like 25% of yours. If you have 5 children, they may only get a benefit equal to 15% of yours, because the family max will have been reached. But that's something beyond really the scope of what I do. I just, I'm aware of it. And then when they do the calculation, depending on how many auxiliaries you've got, you just need to be aware there could be a family max issue there. But that's what auxiliaries are. Sue says and you said you've been waiting for 4 years. Sue, I hope you're right. But I'm just telling you, does not smell right to me at all. Jackie, one of my clients' spouses, is there a way to find out the monthly payment with the processing center? Them from no award letter yet. They will have that information. Not sure why it's taken. So, I mean, again, it's been about a month. I think I looked in your case or in your husband's case. I didn't see it. Sometimes I do see it. I don't think I saw it in his case, but if you ever got a My Social Security statement, that would tell you, but I think they cut that off for some reason when you've got an active disability case. But yeah, the processing center should know. But we're coming up on a time where they should be processing this, and I'm not sure why it's taken this long, because it's been almost a month. But we should hear something very, very soon. Choice. In recon, they said my claim is federal quality review. Couldn't have been approved. The phone, have to wait for a letter. If you're being pulled for quality review, that's usually a good sign. It means you've probably been approved. But we have no control over how long it takes. That's the issue. This is Life 85. Let me just go down here. Okay. This is Life 85. A friend of mine is currently under review for CDO to recommend getting RFC forms during the long form prior to singing. Yeah, I mean, I think that if you can get function, I think you can be proactive. It's always a good thing. So if your friend got a CDR, long form CDR, asking a bunch of questions, and you can get a functional capacity form completed by a doctor, send it in. Be proactive. Absolutely. Don't want to do that. You definitely want to be as proactive as possible. Make their life easy. I mean, you got a bunch of really busy people, and you get a CDR thing back, and it comes back with 2 or 3 functional capacity forms saying this person's still disabled. It's going to make their life a lot easier. They may just decide, let's just go ahead and close this one out and say the person, met the standard. So that's good. Okay. Scattles. I just got a fully favorable from the ALJ, and her decision should in my medical records weren't even reviewed by the panel of doctors. We dealt with this scenario. There was a new emergency ruling, or emergency message that came out that said in certain cases, Social Security was going to bypass the medical review, at the state agency level, but that was only to be for a fully favorable decision issued. I'm not sure what that means. Medical was not reviewed by the panel of. I'm not sure what you mean, panel of doctors. But you know what? You got a fully favorable decision. I wouldn't worry about it too much. I mean, I'm not sure what that exactly means, but fully favorable is the only thing I'd be concerned about. So I don't really know what that means. There's no panel of doctors at the hearing level. Again, there's an emergency message that says that in states where there's not enough medical specialists, that an adjudicator with a certain level of experience can issue a fully favorable decision based on the alleged onset date without going through medical review. And again, that's to capture those really strong cases. But that doesn't really apply to hearings, so I'm not really sure what the judge was talking about. Do you recommend getting doctors to fill out? Yeah, if the doctor will do it. I mean, look, anytime you can get a functional capacity form filled out while you're in a review, in evaluation, you should do it. Because again, you want to be proactive, give them information they can use to make their, to approve you or to, support your continuation of benefits. A functional capacity form, if you think about it, what it really does is it translates medical findings into very specific work limitations. And so the more of that you have, the better. Sharon, one of my clients, yeah, we were wondering about that because I got paid on your case. I did get paid last week, so I'm not sure what's going on. We'll have to try to figure that out because you should have been paid. I'm not sure what the holdup is. So I will, we have Stephanie in my office will be the person to check into that. So let me make a note. Jen, assign that to Stephanie. No pay. Yeah, because I got paid, so you should be paid. Normally I get paid the same time you do. So that's not making sense to me. RFC. And Sharon's case, by the way, is one of those that we got approved the day before the hearing. RFC from the PA, physician's assistant with 10-year treatment records, SSA, discount, no. They will give it, I think a PA is considered an authorized source or an acceptable medical source, gout, deformity, multiple flares. I think that'll be fine. I think that, nurse practitioners, PAs, they realize that, medical doctors use PAs and nurse practitioners, to do a lot of the work. And I think an opinion from the PA should be fine. I haven't looked at that particular ruling, but I'm pretty sure that a PA would be okay. worst comes to worst, you ask the PA to take it to the doctor to co-sign it. But I think that should be fine. I've used it many times. Yeah, okay. And This Is Life says PA isn't. Yeah, I believe it's an acceptable source. Shub says, I'm sorry if you're working, you're not really disabled. It depends on how much you're working. I mean, again, under Social Security rules, if you're under SGA, and let's say you're working 1 day a week, earning $300 a month, that doesn't mean you're not disabled. So with all due respect, I think it's, just the fact that you're earning money means that you're trying to do better yourself, but it doesn't mean you're not disabled. It just depends. And Social Security got very specific rules. You're earning under $1,620 a month, you are not working for Social Security purposes. In fact, at hearings, if I had a hearing, again, coming up tomorrow, where my client's earnings, like been very, very low, but 1 year, a couple of years ago, when I think SGA was 1,310, and I calculated it out, it comes to like $15,900. Her earnings were $15,300 for that year. My argument is she was below SGA, therefore there's no past relevant work. We'll see if it flies, but working at a low level, low earnings record does not mean somebody's not disabled. Okay, Michelle Williams. I was approved in August of 2024. Let me change the crawl here. Michelle says, I was approved in August of 24. I have Hashimoto's with thyroid condition, rheumatoid arthritis, some anxiety and depression. Not looking forward to a CDR in 12 months, which will be August. Don't assume you're going to have one. I mean, maybe they do, maybe they don't. But, I think if you've been going to the doctor and the condition has not changed for what you were found disabled on, you should be fine. I mean, if you've not been working, if you've been working, that could be a wild card there. But if you're not working, I think you should be fine. All right. Elaine says, I'm already off for 8 months from bilateral, put on here, mastectomy, chemo, and radiation, still very weak. EDD is only 1 year, which I guess is the California disability. What will happen if it's more than 1 year? Well, I think that if I'm not mistaken, breast cancer with reconstruction, the assumption is, let's take a look at that. And I'll show you what I'm looking at in a second. All right, let me go here. Let me share my screen so you can see what I'm looking at. Okay, so here is the listings, and we're going to look at listing 13. That's not going to show. Let's see here. Stop sharing. I got to go back and redo this one here. Bear with me 1 second. Present, share a screen. Okay, so here is the listing for cancer. And if you look at breast cancer 1310, it says, this is how you meet the listing. And okay, this one says with secondary lymphedema, the bottom line is to consider under a disability of at least 12 months from the date of surgery that treated the secondary lymphedema, therefore evaluate under the medical affected body system. So generally speaking, after surgery, they assume that you are disabled for a year after the reconstructive surgery, if lymph nodes are involved and so forth. So, you've been already off for 8 months, still weak. So again, you can argue that disability continues because you're weak and sick, and there's radiation and so forth. That's a presumption. You can go beyond that, and you can say, I continue to be unable to work because of the symptoms and so forth. And again, you can realize you could argue, I meet a listing for the first 12 months, and then now I'm either equaling a listing or my functional capacity has been so reduced I couldn't do even simple sit-down work. So you can kind of morph it from one theory of disability to another in the middle of your case. Okay, Michelle says, I'm 54, be 55, skills are not transferable, have not worked. So you met the grid rule at 54, you're going to meet it even more so at 55. I think you should be fine for the CDR based on that. Sandra says, does SSDI automatically go to early retirement at 62? No, they automatically go to full retirement at full retirement age, 66, 65, 66, not at early retirement. So you want to stay on disability until you hit full retirement age. Trial work period is really nothing to do with that. But once the trial work period's over, if you're, let's say, 63 and you go over SGA, you got a potential problem. You got an overpay status. Once you hit full retirement age, then trial work period is not an issue because you can earn as much as you want at full retirement, but they automatically convert it at full retirement. Any shenanigans? How do people get the doctor's opinions when the cost of the doctor is so expensive? Don't have much documentation. I would tell you, Annie, I'm less focused on getting functional capacity forms than I used to be because of this very reason. Doctors are busy. They don't want to do it. Doctors, sometimes want a bunch of money for it. Clients don't have it. I think treatment records are probably more important. This is one of the conundrums of this practice area, in that, as I said before, if you're not going to the doctor, Social Security assumes that you're not disabled. That's not true, but that's what they assume. So you got to find a way to go to the doctor. If you go to a hearing, you haven't been to the doctor in 2 years, you're probably going to lose. But medical records I win a lot of cases of medical records without a functional capacity form. It's great if you can get one, but not at all absolutely necessary. But it is a problem. Okay, so tell it all now. This is the person with ODD, broad-based osteophytes, which is arthritis basically, or bone growth, bone spurs, herniated disc at L3, L1, with moderate to severe spinal stenosis, failed fusion, long and terribly misplaced. Yeah, I think, and then how do I prove it besides x-rays? My doctor died, can't find a doctor because of screw placement, literally had to prove it. SSI will not send you to an FCE. They will send you to a consultative evaluation. They will not do, and of course, if you've got instrumentation, you probably aren't going to get an MRI anyway. Probably do a CT. What you might want to look at doing, and again, you're kind of getting into strategy, and I don't want to really get in the weeds, at this form. But what you might look at doing is getting, seeing if you can get an MRI. Although I don't know if they'll do it because of the instrumentation. Maybe a CT. You can find facilities that will do these tests without a doctor involved. So you can get those tests. You can go to a physical therapist and get a functional capacity form or functional capacity evaluation done. Yes, it's hard to find a doctor who wants to get involved in a case where a person has significant problems, although it's not impossible. But I think, you might have to, again, go to a physical therapist, pay for a functional capacity evaluation, go to an imaging clinic and get a CT so you can document what's there. It's going to be more difficult. And again, if it's SSI only, that may be why you're having a difficulty with the lawyer. But no, they're not going to send you for an FCE. They're going to send you to a consultative who may be a general practice doctor who's only going to look at x-rays, which don't really tell you anything about soft tissue problems. You're being treated at Johns Hopkins. Okay. And again, I think that it's a complex problem. Again, the Lyme disease would add to the puzzle. It's going to really come down to, I think, to some extent, what your financial and insurance situation is, whether you can find a doctor. But I think, one thing I would at least look into would be going to a physical therapist for a full-scale FCE, functional capacity evaluation, and or going to an imaging clinic to get a CT or MRI. Okay, I have an undiagnosed dizzy balance issue, so some sort of a vestibular issue, it sounds like. Am I third neurologist, something that would qualify you? It's going to be a lot better if you get a firm diagnosis, quite frankly, Kevin. I mean, when you've got something undiagnosed, which means it's idiopathic, they don't know why it's happening, that doesn't mean it's not real. But it would be, Social Security gets a little concerned about those things because, you're basically asking the doctor to believe you. And, doctors may believe you. And I've had doctors believe people with migraine headaches, for example, but it's going to be more difficult than it would be if, you have a firm diagnosis that there's some inner ear problem or, something in the brain. So it could be 62 certainly helps. Again, you very possibly grit out at light if you can't stand for 6 hours a day. And if you had a doctor who would say that, but I would feel better with a firm diagnosis. Um, okay, tell it all. And again, I know, it's very frustrating here. You closed your business, and again, I think, if you're not insured and you're SSI only, that's an issue. But you may have to generate your own, create your own medical record. I know it's frustrating. Kimmy says, please let me know if SSDI turns retirement to it. No interview. It's automatic. I don't know for certain. I don't think you have the option of telling them no. You want to stay on disability. I could be wrong about that, but I think that you are automatically, if the money's going to be the same, but I think they automatically do it. I'm not I don't deal with retirement issues, so I don't really know. Phil Zass. Have there been any changes to the way 100% disabled veterans can get paid? No, not to my knowledge. There's been no changes. I think it's pretty much the same as it always was. So, which means you get to the front of the line, but that's about all that you're going to get. Let's see here. Okay, Kimmy. Thank you very much. And by the way, there was another person here. I'm just going down a little bit. Kelly Maynor. Kelly, that's awesome. $49.99 super sticker. Thank you, Kelly. I really, really, really appreciate that. That was extremely generous of you. And I just want to, recognize you. Thank you very much. I really, really appreciate that. That may, I'd say I'd buy lunch for the office. The problem is that Jen's in Nebraska and Madeline's in Oklahoma and Paola's in Mexico City. So they're all different places, but, it will go to the Jacob Ginsberg Lunch Fund, no question about that. Yeah, again, I think tell it all. It's just, there's got to be a reason, why lawyers aren't taking your case. I don't know what that reason is, but I'm sure they're telling you the same thing. Because if you've got John Hopkins for Lyme disease, you've got all these back issues, medically, it sounds pretty strong. So there's some other reason going on, and I don't think you can tell us what that is, but that does something's not adding up. Do they change your SSDI diary date to 7 years after you turn 55? I'm not sure what you mean by diary date in terms of review. I don't know that it's automatic where they change your CDR time period. Honestly, I don't know how that diarying works. That's a very interesting question. I'm going to ask maybe Greg knows. Greg Brinkley's the Disability Yoda. He knows, or Ed Weir, they may know about diarying for CDRs. I just don't know anything about that. That's a very good question, but I don't know. Yeah, I would agree. Don't lay down. Go to do it yourself. Absolutely. Teresa, good evening. Given up to as approved for SSD after my alleged onset date. Judge moved to March 25th. 25th of the function report filled by doctor. Yeah, so you got the onset date changed. So you just lost out on, a couple of years of past due benefits. The question is, do you appeal that? Now at a hearing, you'd have to appeal it to the appeals council. So you probably want to talk to, an appeals lawyer about whether there's grounds for appeal there, and whether you want to take that risk. And, why would that do? It's just, some judges feel like, well, if it wasn't written down, it didn't exist. And that's ridiculous, but that's the way some judges do it. I have no other answer for you. Concho Pete, am I allowed to go to the country when you're SSDI? It depends. If you type in to Google collecting SSDI out of the country, out of the United States, it will tell you what countries you can do that in. Some countries you can do it without a problem, like England or France. Other countries like Vietnam there's some special rules for. Don't go to North Korea. Obviously, won't pay you there. Don't go to Venezuela. Don't go to Iran. But other than those countries, I think that most places you can. Russell says, back in 2019 to apply, I found this website, watched several videos, helped me understand. Absolutely, that's why I do it. I'm glad you found it, Russell. Thank you very much. Representative said not to appeal the changed onset date, and maybe there's a reason for it. I don't know. But yeah, it's risky to appeal an approval. But you can certainly have that. Tell it off. If you want to email me, that's fine. Again, the question I'm going to ask you is, what are the other attorneys telling you? Because again, I don't think it's the medical issue. There must be some other factor. But if you want to, there's a form at the bottom here. If you want to contact me, tell me what your, who you are, and that you're Tell It All now. I'll get back with you. We can go over it. I'm probably going to ask you some questions by email. I'll tell you. I mean, I have to be. I've got to limit my time on the phone, because sometimes people call up and they want to, they want advice. I understand that, but if it's not a case I can handle, I can't spend 45 minutes on the phone. So I'm going to ask you some questions, and if it's something I feel I could help you with, we can schedule a call. But I'm going to have questions for you. But if you want to send me something, feel free to do that. Okay. Yes, that's right. Fortunately, Russell, you're not the first one that basically told me that the videos were helpful, and I do kind of vaguely remember that. Yes, when I get an email from somebody that says, you made my day, I won because of you, like, that's great. That's awesome. I've had people send me money. I mean, I've had people. I had one person several years ago. It was crazy. Send me $500. I won my case because of your videos. I'm like, wow, that was pretty amazing. That's pretty rare. I'm not saying people should do that, but I mean, a guy had a kind of a complicated case, and I think I'd answered some questions for him by email. But yeah, people, I look, reviews, thank yous, all that stuff is very gratifying to me, because, and I know, when Adriano was on last week, we talked about that. Just, people, when they say thank you, it means a lot. In this crazy world, a lot of people don't. And again, I've got seems like a nice group of folks in this community. People have been very appreciative, which I really appreciate. But goes a long way. So thank you. You are welcome, Russell. Thank you very much for tuning in. So you were 50, pretty close to your onset. Yeah. So I mean, I'm happy to have, what I do when I'm looking at and appealing a case, there are a couple of attorneys, Carl Osterhout, Brian Kanofsky, I'll send the decision to. If you want to send me your decision, I'll look at it and maybe have somebody else look at it, tell you if it's worth, if the risk is worth it. Again, you got to be really careful about appealing an approval. It's dangerous. But if you'd like me to have somebody look at it, I'll be happy to do so. Just contact me at the thing below, at the email below. Yeah, Russell makes a good point. They are using offices because of the personnel issues. They're using offices all over the country. I mean, I had a hearing for a client in California. The hearing was with a judge in Kansas City, and the vocational witnesses in Mississippi. So it's not unusual for them to be all over the place. Okay. Does ALJ review the case? Yeah, de novo. Basically, if you have a hearing, the ALJ will tell you this is what they call a de novo review, which means they're looking at everything completely blank slate. So previous decisions are not binding on them at all. That's what de novo review means. Novo meaning new review. That's what they do at hearings. Okay, Tell It All. And again, I'm not going to. I know I know. They're telling you not. And I get that. And again, I'm not doubting what you're telling me. I'm just curious as to what the other attorneys have said, because with medical, the way you're describing it, seems kind of odd that you're not getting anybody to touch it. You're welcome on in Scorpio. And again, Kelly Maynard, thank you very much, Kelly. Very, very nice. What if the DE and MC massively violated laws in the ALJ hearing upcoming? How to address that? What is the DE and the MC? I'm not sure what those are. I'm not familiar with those abbreviations. I just don't know. So MDC, if you can tell me what DE and MC are. I mean, I think at the end of the day, whether, when you say they violated laws and rules, I mean, if you mean because they didn't approve you, the way they applied it, that may not be a violation like what you're thinking. At the hearing, you're going to get a new review. So I think that's probably what I'd focus my energy is on the hearing, because that's what's going to mean, whether you win or not. Okay. Okay. Well, again, tell it all. If you go to contact Jonathan 3 and put in, that who you are, that you were in the live stream, yesterday, or tonight, whatever, and just, send me a review. Just use the form, because it comes to me in the morning, and I will look at it and I will get back to you. So that's the best way to reach me. Kelly says, just finished my 3373 faxing. Very good. Very good. Made feel like the unwanted redheaded stepchild of the medical establishment. I hear you. I know it can be very frustrating. Very frustrating. Work 14, 18 hours a day. Your work career motto is I'll sleep when I die. I hear you. St. Louis Grant. Walter. I assume you're talking about Walter Knott. Walter is a disability attorney, and I think he's in Tampa, Orlando. He's very, very active on YouTube and social media. And he's got some good stuff out there, but he's very, very active. Again, very different approach than me. If you watched him, he's a little more high energy, a little more, just zoom. Kind of gets, sometimes he'll talk about a lot of different things, but, he shares his time and expertise. And I think that's great. I think it's great. Okay. Hello, says Karen Flowers. We'll get about 10 more minutes. I'm receiving disability starting December of 44. I've got my back pay. Any idea much longer? I really need bills. Thank you. Yeah, you should have it by now. I would, either if you don't have an attorney, I would contact your U.S. senator and ask them to do a congressional inquiry. That will get you an answer quickly. And I promise you that. So that's what I would do. Okay, tell it all. I know you've got a bunch of other things here, but I want to I got about 10 minutes left, so I'm going to focus on folks who I haven't responded to yet. Let's see. That's Lily Silver. How to get on? She's really? I did not know she had passed on. Okay, I never knew the name of the person. I hadn't looked at that site in a while, but okay. Thank you for letting me know, Lily. I did not know who that was. Okay, very, very interesting. That's I need to really look at it, but the site's really good. Okay, that's interesting. Okay, well, thank you for letting me know. How can I move for ALJ summary judgment, massive law? Again, I think you're going to have an uphill battle. I think it's going to be an uphill battle to do that, because this is administrative. Summary judgment is a judicial concept, and that's going to be hard to do. You need to get into district court. I just think that's going to be much more. Focus on winning your hearing, I would tell you. Emmett Jones says, what's federal quality review? Basically, when they look at a case and they make a decision, there's a process where some cases are flagged for review, where they make sure that the process was done correctly. That's a quality review. Okay, well, thank you, Tell It All Now. Appreciate you. What happens when I'm getting SSD when I turn 65? Contacted centers, they're going to convert it over to retirement. What's going to happen? Yep, I think Russell is absolutely correct. Absolutely correct. Okay, T-Lux. Hello, T-Lux. How are you doing? Kathy Stewart. 3 of 5 approved for SSD for 6 year, 7-year-old husband, like 4 and 5. Husband applied to, those steps, there's no specific time. I know Chad Brown did a video about this, and he talked about that all these steps, they could be a week, it could be 6 months. So it's just a label, but there's no specific amount of time that I can tell you that it's going to take. Lisa says, can you receive both SSD and SSI? Not just Massachusetts, any place. Only going to typically, since SSDI is going to be more than SSI, once you get SSDI, SSI stops. I've seen people get SSI for the 5-month waiting period for SSDI, then it stops. Or in rare cases, if your SSDI is, let's say, $700 a month, your SSI is $900 a month, you'll get 2 checks. That's really, really rare. But usually it's the 5-month waiting period when you get it. Ray, hello, Ray. Tell it all now. No doctor will treat my back because of misplaced screws. I believe you. And again, I understand, I understand. I mean, this is a problem that doctors will sometimes not treat people who have significant medical issues. They don't want to get sued. They don't get in the middle of it. And, again, that evidence, for everybody's purposes, if you get doctors telling you, I won't see you because your back is so screwed up, that can be helpful evidence. But again, I think a diagnostic test like a CD would be helpful. Lisa P. Thank you, Lisa P. I really appreciate it. Teresa Bond, thank you for your knowledge and assistance. You are very, very welcome. Very welcome. Russell, when I first applied, put my SSD, and they approved me for SSI, and yes. So that's right. Typically you're going to get less than an SSI than SSDI. Dominic Lewis, is it normal to get a 3-month app for appeal by audio? I don't know what that means, Dominique. Is it normal to get a 3-month app for appeal by audio? Sorry, I don't understand what you mean. Don Tufts, I've got an adult son who's 20 years old with autism, probably mid to low level functioning. Likelihood, I mean, it's an uphill battle with anybody in their 20s. You're going to need a lot of medical support. I would look at, somebody else in the family, if you or his father is on Social Security retirement and disability, he could pursue a disabled adult child, but on his own, he's going to have significant evidence basically that says he would not be capable of doing any kind of work at all. And you're going to need a lot of medical evidence because they don't like to approve 20-year-olds because it's going to be on the system for a long time. Christina says, please like the video. Russell says, they approve. That's true. Russell's right. I've seen that happen many times before. Absolutely. Is it normal not to have a medical expert appeal? Well, at a hearing, it's pretty rare not to have a vocational witness. Medical experts are not that common, but vocational witnesses are pretty ubiquitous. I'd say most of the time you're going to find one there. Okay. So one of the people in my office is putting, we're 45 subscribers away from 80,000. So if you hadn't subscribed yet, let's get to 80,000. That would be great. 500 videos. Okay. I don't even know how many videos I got out there. I just record them and get them out there, but I haven't really counted lately. Yes, Christina says, please subscribe to the channel. During and CDR, what's the best way to convince doctors to sign the RFC form, say moderate mark limitation? I mean, you got to sit and talk with your doctor. I think you just got to really, really talk with your doctor. I mean, that's the only thing I can tell you. I mean, you can't force them to do anything. You got to just talk to them and try to convince them that they need to help you. All right, Tara, how are you doing? Step 5, we're getting close. We are getting close. Tara's one of my clients. We're getting close. Janelle says, the V says they're going to be a motor vehicle assembly. I haven't looked at the VE or the DOT on that. That seems like a pretty heavy job. So you know what? I would tell you, Janelle, download the hearing audio and listen to it closely and write down the VE, the DOT code for that job and look it up, because motor vehicle assembler is going to be a heavy job, or medium or heavy job. And if you're being in childcare, that doesn't make any sense to me. I mean, that just means the judge found that you're capable of medium work. I mean, that just doesn't make any sense. And Luke, thank you very much, Luke. I really appreciate it. Okay, that's very interesting about the Lyme disease. Yeah, it's a tough one. I've won a couple of cases on Lyme disease, and it's tough. I know there was a woman in Virginia, a doctor who was a Lyme specialist, and I had a client go to her, and that was helpful. But yeah, it's a Lyme disease is a really tough a tough thing to get past because it can be truly debilitating. I have personal friends who've gone through it, and it's tough. It's tough. But actually, in fact, I know somebody who might benefit from that. So it's Anthony William, right? I will pass that along. Medical medium. Um, can you get, we get time for a couple more here. Can you get SSDA for plantar fasciitis, 4 surgeries, and still can't stand? Um, again, if you're over 55 and you can't stand for 6 hours, yeah, you could grid it. You could meet the grids. It's plantar fasciitis is not normally a disabling condition, but if you've had multiple surgeries on it, I think you would have an argument for that. Yes. Um, Kimmy says, "Thank you. You're very, very welcome." Carrie Crawford, hey, how you doing? You're the one with the Harley, okay? Holding on my bike because I have my spinal reconstruction surgery. And you get back to riding. I know. I wasn't picking on you, but I know when we talked about that, that was my thought. Is okay. Why are you holding on to the bike? I don't think it's going to come up in your hearing, but that was just something I just thought of that because we just talked about it the other day. But yeah, I think that if that would come up, you would need to explain exactly that. And I know the surgery you're talking about is a pretty intense surgery. And I think, look, it's the same argument that somebody would say, they're holding on to hope for something else. And I don't plan on bringing up the fact that you own the Harley, just that, if it was in the record and a judge asked you about it, the question is, would a judge truly believe that you've got it in the garage and you're not riding it? That's the whole point I was making. It was not a knock on you. But anyway, I know it's kind of funny because we did talk about that just earlier this week. How long, as filed, does the appeals counsel? Usually 6 to 8 months, sometimes a little bit longer. Okay, I'm going to answer a couple more questions. Do you recommend submitting letters from your doctors at the same time you submit your application? I don't think it hurts. I don't think it hurts at all. So why not? The more proactive you can be. Is it better I submit to the judge? I think it's better if your lawyer did it because, a letter to the judge saying I'm in a lot of pain, they know that. I mean, you got to really talk about what the record says. So I don't think that's going to be all that compelling. I think that if your lawyer can make a legal argument, you meet the grid rules, you meet your functional capacity argument. Okay, Luke. Yep. So, okay, very good, Luke. I appreciate that. And you're I think the Lyme disease person. Okay. Okay. Why does Ed Weir scare everybody to death? And Ed Weir is a former Social Security, and if he's got a YouTube channel, I think My Government Expert or something is his handle. But cuts to Social Security because it's a concern. I mean, it's he worked there, and I think he knows how hard they worked and how how many people they didn't have. And when they start talking about cutting, a 25% of the workforce, it scares them. I'm just taking a wait and see attitude. But yeah, it's a concern. It's definitely a concern. I feel better we've got a commissioner, but I think that many people believe that this faith in AI is misplaced. So we shall see. We shall see. Okay, and this is the person who's asking about the illegal acts by the disability examiner medical consultant. It's going to be really hard to prove that. And again, if you got to an appeals level, again, this is administrative, so I think the focus is going to be on the hearing. You can certainly reference it, bring it up if that comes up, but I just don't know that a judge is going to really hear about it, quite frankly. Shub, some of these people ain't got snowboards. Sometimes, yes, you'd be surprised. I will tell you, Shub, there have been cases that I'm like, it's going to be a real uphill battle and we get approved. I've had other cases where like, this case is a strong case, you get denied. I think anybody who applies for disability, it's a big step to take. And most people aren't going to do it unless they have a legitimate feeling they could be approved. Um, but yeah, there are people who are going to have a really, really hard time. You're 35 years old with fibromyalgia, really hard. It can be really hard. I'll tell you that. I'll tell you that. Okay. I'm going to answer a couple more questions. Teresita, good evening. Thank you for Doom. I received my letter from Social Security saying I'm medically disabled. Need to review my non-medical. That means they're looking to see if you had any work, because you meet the qualifications medically, but they're going to see step one: are you engaged in substantial gainful activity? Because tax records are only reported once a year. They're going to do their own investigation by asking you questions and looking at some various places to see whether you have any work. That's what they're doing. Okay. All right, let's see if I got any more. All right, I think good night, everybody. Keep fighting. Absolutely. Wayne says, great live stream. Thank you, Wayne. I really appreciate you tuning in. And I hope I was helpful. So, okay, we've been at it for 2 hours and 5 minutes. I appreciate everybody taking the time to join me tonight. Again, I've got some guests coming up, and but this is great. So I appreciate all the questions. We had a good number of people on tonight and some really good questions. And those of you who would like a case review, please use the link. So we will talk to you next week, and have a great weekend, everybody. And again, Jonathan here. I will see you next week. Take care. Bye-bye.